On the record and State versus Brooks appearances are as they were before. Just want to make a quick record. It's not something we need to address right at this moment. I provided to the parties the pattern jury instruction 152 related to jury view, and then an instruction I drafted based on that, and I say based on that because this has to do with the view of the vehicle, because I view a view of a scene differently from a view of a vehicle, which is evidence. So again, we don't need to go over this now, but I at least wanted to give those to the parties so that when the appropriate time comes, we can discuss whether the court should say anything regarding the view of the vehicle, if that is in fact still the request of the state, and then if so, what that should be. So I've provided that to both the parties in written form. Go ahead.
Judge, actually, I appreciate that, and I wanted to bring this up this afternoon so we can plan. Obviously, I don't know if the mics are on.
It should be, yes.
Okay. I'm soft-spoken, I'm sorry.
Said no one ever. Oh, that was all loud, sorry.
So, with the court's permission, we would like to schedule the jury view to occur at 12 noon tomorrow. Now, we may not be through testimony at that point with the state's case, but like we did with the interpreter, if we could get a commitment from the court to pause whatever we're doing around 11:45 or 12 noon tomorrow and lead the jury to the location for the jury view. There's obviously some planning that needs to take place by the sheriff's office. The tow truck needs to be arranged, and I believe the maintenance division needs to assist in some way as well. So what I'm learning is that it's best if we just pick a certain day and time and set it, and then, you know, again, with the judge's permission, kind of work around that in the courtroom. So that is our request, if the court is willing to accommodate that.
In regard to that request, I know I had internal discussions with the sheriff's department because they're in charge of security over the trial, and I don't frankly know how much we've talked about this previously, but it is in a secure location, or will be. I've made arrangements, or I've instructed the sheriff's department that because of the location that we will be in, it's not something that will be that anyone can just follow us to, right. But contemporaneous recording will be made and then placed into the record so that the public is aware of what happened, but after. So I did want to add that to the record. In terms of the request, Mr. Brooks, this relates to the viewing of the vehicle that was recovered by the Waukesha Police Department. There were preliminary discussions when you were still represented by counsel, and the request is being made that the viewing of this vehicle take place tomorrow. Your response, if any?
First of all, I accept for value in return for value this paperwork. I guess I'm still confused as to why there needs to be a jury view.
I can have the state put their request on the record again. I'm responding to their request. So go ahead, Attorney Opper.
Yes, Judge, and I believe the court has already approved this request. The motion was filed and ruled on by the court previously, but as Mr. Brooks has been charged in every count with acting while armed with a dangerous weapon, we believe it's relevant and appropriate for the jury to view what we're alleging to be the dangerous weapon in this case, that is the 2010 Ford Escape. It's essentially, would be no different than bringing a firearm into the courtroom during a shooting case.
And I would just simply note the first-degree intentional homicide and first-degree recklessly endangering safety charges are what carry the enhancer for use of a dangerous weapon. Of course, the hit and run does not have that enhancer, nor do the bail jumping and batteries, but with that caveat.
Yes, thank you for that correction, Your Honor.
All right. Mr. Brooks?
I'm confused to that too. Why are there only certain charges that have an enhancer?
Well, the court's not going to answer that, sir. Those just happen to be the charges. The state is tasked with proving each one of those charges and any special verdict question that goes along with it. Beyond a reasonable doubt, they bear the burden of proof, as was spelled out in all of the preliminary jury instructions. So that's how I'll answer that. In terms of the jury view, I did grant the motion previously. It was unopposed, and I'm not hearing anything that would cause me to reconsider that. In terms of the time that's being requested, do you have any position on that?
Do I have to be present for this?
I would like you to be, and yes, we're making arrangements for you to be there, sir.
Do I have to be present for it? And also, for the record, I don't consent to the name that's being referred to.
I'll use this opportunity, sir, to ask what name you prefer to be called, because we now have evidence in the record where you provided your name to, upon questioning. There was video from when you were taken into custody, and then, of course, Detective Carpenter has testified about that as well. Again, I try to refer to the parties by name because that is how I believe I demonstrate respect and decorum in this courtroom. And we've been given no other name, sir, by which to call you by. And I must, at that point, go back to what's on the criminal complaint, which is the initial charging document. That is what was filed in order to initiate the case.
With all due respect, the record should be corrected. I didn't put anything on the record that was...
I didn't state that. I said there's
You said
evidence in the record.
Well, evidence, what you referred that evidence to me.
Sir, there's evidence in the record, but be that as it may, I'm just letting you know I'm going to keep referring to you sometimes as defendant, sometimes as sir, sometimes as Darrell Brooks, sometimes as Mr. Brooks. I understand you may still have an objection, but I've been given no other name from you by which to call you.
I follow, but there's still a lack of understanding. Are you referring to the name that was in all caps on all the filings?
Because every filing that I find the response to be kind of disingenuous, sir.
So it was
this is, I believe, a tactic by you to create some type of confusion, which I don't believe there is any, about who you are and what name I need to refer to you as.
I never said you had to refer to me by any specific name. That's not what I'm saying. I'm saying that every filing that has ever been filed was in capital letters. That's a fact. I have paperwork to prove that. I don't recognize that name, nor do I know any individual by that name. That's all I'm stating.
Well, let's assume for a second that it's not in all caps. Do you recognize that?
No, I do not.
Okay, well, we never answered them. We're going to keep going, sir. We're a little bit off topic. In terms of the request by the state, I'll give you one more opportunity to answer that. They've requested that whatever we're doing tomorrow morning, whether it be their case, whether it be if you are calling witnesses, that we pause about 11:45 in order for the jurors, the court, and the parties to be taken to that secure location for that jury view. Do you have any position as it relates to that?
Yeah, my position was, when I answered, I said, do I have to be present?
I'm requiring you to be there, yes.
And what reason do I have to be present?
Unless you're willing to go through a colloquy with this court and intentionally waive your right to be there, because then I'm going to require you to be there.
And that's not explaining why I have to be there, though.
Because I'm requiring you to be there, sir.
And you just made that decision now?
All right, he's not answering the question that I asked him. We will pause at approximately 11:45 tomorrow morning for that jury view of the vehicle to take place as soon as we're able to walk over there, but I think given the logistics of everything, it is on campus, but it is in a secure location. That will take place approximately at noon, and as I indicated, the court will require the Sheriff's Department to make a contemporaneous video of that view, which will subsequently be made part of the record to capture that.
Don't I have rights though, Your Honor?
All right, then with that,
Could I ask another question?
Go ahead.
Scheduling, Your Honor. Could you please indicate your intentions as to how late we will proceed this afternoon so we can line up witnesses?
sure, I'd like to try to, we had a little bit of a long day yesterday, so I try to balance that out for the jurors. So generally between, 4:30 and 5 is when I would like to break, depending on where we're at. If we need to go a little earlier because of the witness, or if we need to go a tad later, that's fine as well.
Okay, and then the last item, Your Honor, is that, to my knowledge, we still have not received anything from Mr. Brooks as to the date and time when he would like his witnesses ordered to appear. I don't see anything was e-filed, so if he is still requesting the assistance of the state to secure the appearance of those witnesses, we will need that information, Your Honor. He does not have to give us the exact order, but if he could tell us, as you had suggested, either morning or afternoon, and what day of the week he wants these people here. We have served the subpoenas that he requested at his request in order to assist him. And these witnesses obviously have jobs and other commitments, so it's reasonable to be able to give them a time frame on when they need to be here.
With that, when do you expect to rest?
We're still hoping to rest by the close of business tomorrow, Your Honor, unless something unforeseen happens.
So we're talking about Thursday and Friday at this point.
Yes.
Which is what I suggested from the beginning yesterday.
But Mr. Brooks, we need to know which particular witnesses, on which day, and whether it's AM or PM. Don't need to give me the order, we'll have them come in groupings, but it's not reasonable that they all come on the same date.
I never
So-
said it was.
All right, so you need to provide that to the DA.
How am I supposed to provide that to the DA?
You can write that down, or you can put it orally on the record right now. I asked you to bring it with this morning, and I didn't cover that this morning, so you were put on notice of that. But I'll give you until,
I was put on notice of what?
let me ask Attorney Opper a question. Would tomorrow morning first thing be sufficient for the state to make those arrangements, given that you don't believe you will close your case until the end of the business day tomorrow?
I understand what the court's saying. I think that's reasonable, with the understanding that if somebody needed to give notice to an employer and it can't be accommodated, then that may affect things for Mr. Brooks. But I think 24 hours notice is generally reasonable, and we will do our best. We can assure the court we will do our best to get them here, but I don't know if we'll be able to exactly accommodate the timing that he may or may not want.
All right, so Mr. Brooks,
Objection to that, because when the subpoenas were served to them, I'm assuming that they would have let any employers or anything know that they were expected to testify in a trial. I don't understand why it will become a problem at the last second.
Well, if you recall, sir, at the end, near the end of last week, I don't recall exactly what day we were on, but we knew we weren't gonna finish with the state's case at some point, and we had a discussion on the record. If there was any objection by you, if the state told those witnesses they didn't need to appear on Friday, so it obviously had to have been before Friday, that they didn't need to appear, and that they would work with those witnesses to provide them with a more definitive time. So now is the time when we need to provide them with more definitiveness. So by the start of court tomorrow, you need to bring with you, either in writing or be prepared to put it on the record orally, which witnesses you want. We'll start with Thursday morning, then Thursday afternoon, Friday morning, and Friday afternoon. I don't need to know the order, but I need to know the day of the week, right? So Thursday or Friday. I would just note the dates for those. Thursday is the 20th, Friday's the 21st, and then which witnesses. Only you know how much you want to question them, so you should be able to gauge if we can get 2 in each morning or afternoon, 3, 4, whatever. Use your best judgment on that.
Yeah, I don't know how I'm gonna come up with exacts on that.
I presume you're gonna prepare some questions and you might be able to kind of gauge how quickly that will go or not. If not,
No.
we'll do our best, but you've got to provide some definitiveness. It's not reasonable to just have these witnesses all come on one day.
I'm informed of what you're saying. I just feel like that same courtesy wasn't afforded to me by the prosecution. They didn't have to tell me exactly what witnesses was being called on what day and all this and that. Why is it not even
I am requiring it, sir, because they are assisting you, because they graciously agreed to do that because you are representing yourself. If you want them to be out of the loop on that, then I can just put it on your responsibility and your shoulders, but that is up to you.
What do you mean by put it on my shoulders?
You can contact them.
How am I supposed to do that?
You have access to a phone in the jail.
So I'm supposed to call everybody that I subpoenaed, not knowing their information?
That is one way to do it, sir. Their information is in the police reports.
That is highly unreasonable. When one person that's on my witness list, I'm not even permitted to have contact
That would
with.
be a good exception to that, so that's very astute of you to point that out, sir. That would be one exception. But other than that, in any event, sir, we're kind of a bit off track. We're going to get back on track, and you need to provide the information that's provided, that I've outlined here today.
I don't think that's fair, Your Honor.
Oh, your objection is noted. It's my ruling.
The state didn't have to do that, but I have to do that.
Sir, I remind you that you are nonetheless required to follow the rules of procedure just as any attorney would have to if they were representing you. You've chosen to represent yourself. The state has graciously agreed to assist. They've served the subpoenas on your behalf. They didn't have to do that, but they did. They've agreed to contact the witnesses throughout so that a better idea can be provided to those witnesses as to when they need to testify. They're simply asking for some basic courtesy so they can then relay that information to the witnesses you want to call in this trial.
I'm informed of that, Your Honor, but...
All right, then let's move on.
That's actually under the confrontation clause in the Sixth Amendment. I should be able to have the right to have witnesses subpoenaed. It shouldn't... Why is that?
Again, we're getting a little far afield here, sir. Subpoenas were provided to you. The record is very clear on that. We assisted you with that. I even reviewed them for completeness, and then the state assisted you with serving them. That is something they are not required to do, but they agreed to do in this case. So nothing about your Sixth Amendment has been violated in that regard.
Did I say violated, or did I say I'm not?
So you need to understand that, sir.
I don't understand anything, and for the record,
All right.
I didn't bring up the word
Let us
violated.
continue then. We're going to move on, Mr. Brooks. Let us continue with the
So we
questioning
gonna move on to
of...
subject matter jurisdiction that
No,
has
I'm
yet to be
not.
proven?
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not gonna address that at all? That's not gonna be proven for the record? Is that a judicial determination that you don't have to answer the question, Your Honor? Is there also a tactic agreement?
Your Honor, the state would move Exhibit 82 into evidence at this time.
All right, you want to do that in front of the jury or just with me?
I wasn't sure if the defendant would have any objections that would need to be heard off the record, or outside the presence of the jury.
Well, can you have them hold for a second? Do you have any objection to Exhibit 82?
Yeah, I got an objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern. Your objection is to relevance? Your objection's noted, it's overruled, and I will receive Exhibit 82.
The court will let the jury know that when they come
So
in.
are you
Yes.
overruling the fact that the true nature and cause has not been presented to me, that I don't know what the true nature and cause of the charges are?
You can have them brought out now.
They were some of them.
All right, thank you.
Just a second behind, but I wouldn't know that it's coming in.
All right.
Your Honor, may I see a sworn affidavit of the nature and authority of the court? Or is that a judicial determination? You won't answer that as well?
Welcome back, ladies and gentlemen of the jury.
I hope the record reflects that.
All right, thank you, everyone. Please be seated. Record will reflect that Detective Carpenter is back on the witness stand following the break for the lunch hour. And Mr. Brooks, you may start your cross-examination.
I don't consent to being called that name, Your Honor.
Your objection's noted, it's overruled. Please ask your
Can be
questions.
overruled. Detective Carpenter. Did you attend the parade that evening, November 21st of 2021?
Yes,
In what capacity?
as a member of the Honor Guard,
And what time did you arrive?
I don't recall the exact time.
What time did you leave?
I don't recall the exact time.
And when you left, where did you go?
Our temporary police department,
Temporary. Explain what do you mean by temporary?
so at the time of the incident, the building we are in currently, which was our main building, was under construction, so we were displaced.
What do you mean by at the time of the incident?
At the time of the parade,
And so the regular station was, what did you say, under some type of construction or something?
correct.
And so what were you guys using for the temporary police station?
The city annex and city hall, we're in two different buildings.
Does any of those buildings consist of a room for interrogation?
There is at the annex.
And so when you initially interrogated the suspect, why was the annexed interrogation room not used?
Well, when I interrogated you, Mr. Brooks, the annex room was not used because the situation was very fluid. There was a lot of information being learned. We knew this was going to be drawn out. There is no municipal lockup facility at the annex, so it could not be utilized.
And so the police holding room in the hospital was more sufficient.
You asked to go up there for medical clearance.
So the police holding room in the hospital was more sufficient than your temporary station, which would have been more suitable?
Yes, it was more sufficient.
And why would a hospital police room be more sufficient than the actual police station that you were utilizing at the time?
As I stated in my previous testimony, there was no secure lockup facility at the station. In addition to that, you requested medical clearance at the hospital.
So was there sufficient lockup at the police room in the hospital?
We had areas in the hospital, so when you were being treated by the doctor, you could be handcuffed to a bed. There is no place in the interrogation rooms you referred to at the annex to handcuff you to anything, and the doors did not lock sufficiently.
And to the best of your knowledge, would a detainee have that information that you just stated?
No?
So how come the suspect couldn't be handcuffed at the annex for the interrogation without having to be handcuffed to a specific bench or whatever you refer to it as? Well, I guess essentially what I'm asking is, could the suspect still be properly detained while being interrogated at the annex versus police holding room in the hospital?
So let me make sure I have this straight. The question is about detainment. Do I have that right?
I think the question was very clear, Detective.
I can't answer it if I'm not going to get clarification.
And where was the suspect taken upon being detained?
You were taken, Mr. Brooks, upon the time you were arrested, down to the substation on Les Paul Parkway in Waukesha.
And do you recall if the suspect was put into a holding room?
Yes.
And do you recall if that holding room had something that would secure a detainee?
Yes.
So why couldn't the interrogation happen there if the suspect could be secured at that location?
Well, there are various reasons, and one of the most important reasons is when we took you to the hospital, Mr. Brooks, for your medical clearance, there were now a total of 4 officers there, myself, Detective Stern, and eventually the 2 federal agents. The situation was still very fluid. When I began the initial the initial questioning, it was 11:04 p.m. and there were still a lot of unknowns. So the determination was made to start questioning you, see what information you might be willing to provide us, because with 4 of us, we were confident we would be able to keep you where you belonged, where we needed you to be, as opposed to risking another unnecessary transport. Because and it's not just personal against you. Any transport of any prisoner, there's a risk. So there's no point in taking that risk of that transport when we had the ability to do the interview there, especially when there was such limited information that we had.
So FBI agents were present at the substation that you referred to?
They arrived there at one point, yes.
Was that known to the defendant?
I don't recall.
Is it fair to say that the detainee could have been Is it fair to say that you could have made sure the suspect was contained while at the substation, seeing as how that there was multiple officers present?
Objection, I think this has been asked and answered.
I think he's referring to the substation versus the hospital, so I'll allow it. Overruled.
You were contained initially at the substation, Mr. Brooks, but you requested medical transport, so you were transported. So what I'm explaining to you in my prior testimony is I didn't know at that point if you'd end up going straight to the county jail or what have you. Every transport, as I stated in my earlier testimony, there is a risk. There is a danger. It's not just personal to you, it's any prisoner. So the decision was made to start the interview there based on not knowing where you'd end up for sure, not having all the information, that we weren't going to take the risk of an extra potentially unnecessary transport back to that facility. You couldn't be held there. You couldn't be held at the sub. There's no beds.
You referred to interrogation starting at a specific place. I'm referring to the substation. Is it fair to say that there was no interrogation that took place at the substation?
Yes.
Yes, that's fair to say?
There was no interrogation at the substation in Waukesha.
Do you recall what information was obtained at the substation?
Yes.
Do you recall what that was?
Yes.
Can you state for the jury and for the record what information you obtained at the substation?
Yes, sir. Basic biographical information. So I obtained your first name, Darrell Brooks, your last name being Brooks, your full middle name, I should say, being Edward. I learned that you were a junior. The date of birth, February 21st, 1982. Additional information obtained was your home address, which was you provided as 4014 North 19th Street in the city of Milwaukee. Phone number, your emergency contact, which you provided as Dawn Woods, whether you were employed, going to school. I remember talking with you about your tattoos and other physical marks that might be on your body. Your hair color, eye color, photographs were taken, things of that nature.
Kept mentioning that name, pretty slick.
Sure, disregard that last statement, sir. Please ask questions. You'll have an opportunity to testify later.
Oh, I got a lot of questions. And at that point in the investigation, what did you initially know?
At that point, we knew that the red Ford Escape had driven through the parade route and that you'd been identified as a suspect.
And why was that information not provided at that time to the detainee?
The information at the time wasn't presented to you, Mr. Brooks, because, as I stated in my earlier testimony, it was still very fluid. It was very chaotic out at the scene. There was still a lot more that needed to be learned.
So is that standard procedure to not tell a person why they're being detained?
Well, we did not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is that the same as...
Can I finish, please? I just didn't bring up the parade part of it.
Why not?
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known, so I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
So it'd be fair to say that it was not a fact as far as the information you learned to that point in the investigation.
Objection then.
Grounds.
Sustained is to the form of the question.
So at that point in the investigation, it wasn't a fact.
Objection, same question.
Grounds.
Sustained is to the form of the question.
At that point in the investigation, the information you had at that time, you weren't sure about.
I guess which part?
All the information that you had up until that point.
Okay, about the prowling or parade, I don't understand which part of it you're talking about.
All the information that you've obtained at that point in the investigation, you weren't sure about. As you just said, you don't try to assume guilt or anything like that until you have all the facts. So at that time, at that point in the investigation, is it fair to say that the information that you had obtained so far, you were not sure about?
I wasn't sure if you were the driver initially, but it was believed you were involved.
And you knew that to be fact?
Yes, the information being provided was that you were involved.
So it would be fair to say you knew that as a fact?
Well, hold on, I'm gonna not allow him to answer that. This jury will determine the facts of this case. If you want to ask him his opinion, you do that at your discretion.
He said fact. He said facts.
You asked the question, sir, so
But he brought it up first.
I'm going to strike the question from the record, and Mr. Brooks, you're directed to rephrase.
I will rephrase, but I do not consent to being called that name for the record.
Noted and overruled.
You stated that there were some loitering and prowling allegations. Why? To your knowledge, were those ever charged?
Objection relevance.
Grounds.
Overruled, the witness may answer.
No.
And do you recall why not?
No.
So why did you constantly tell the detainee that they were being detained for loitering and prowling if you in fact knew that there was another reason why they were being detained?
Objection asked and
Grounds.
answered.
Sustained as to the form of the question and assumes facts not in evidence.
What was the significance of the FBI being present?
The significance of the FBI presence was the early on concern that this was a terrorist-style event.
And you said that this was a terrorist element. And what is the this? Can you explain what the this is?
When you drove your vehicle through the parade and struck people.
Which at the time you stated you did not know is fact, correct?
That was still being investigated, yes, but I know that's what occurred now.
Now versus then.
Initially, it was unknown if you drove.
That's what I
As
was
stated.
That was the question.
But the investigation showed that you were the driver of the vehicle.
And initially, you didn't provide that information, correct?
Correct.
So do you know if the FBI continued their part of the investigation?
Eventually, the investigation was strictly run by our department.
And do you recall why that decision was made?
My understanding is there wasn't a terrorism link.
I'm sure throughout your career you've done lots of interrogations. Are there usually multiple officers that do the interrogation, or usually just one?
It can depend on the circumstance. It's not always more than one, but it can be.
And what would you estimate would be the normal procedure for interrogation as far as law enforcement wise?
I really can't speak to that. I think every department probably has their own potential way of doing things.
Up until that point in your career, when you interrogated the detainee, had you ever conducted an interrogation with FBI present?
Not prior to that date, no.
Made reference to a car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
No, I did not.
Were you told by other law enforcement?
I guess told what exactly?
That a car key was found?
I was not specifically. Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
And to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
At the time that the detainee was detained in the substation.
Thank you for that clarification. Go ahead and answer.
I just want to make sure I guess that I understand. So you're asking me what I knew about the key, or if I knew where it was found at the substation? I don't understand. Can you clarify that, sir?
I guess the clarity that you may be looking for is what was found and brought into the substation?
Okay. The Ford ignition key and other items that I alluded to in my earlier testimony include your photo ID and credit cards with your name, or debit card, credit and or debit cards with your name on them.
That you did not search and find yourself, right?
That's correct.
Did you conduct any searches?
I don't recall if I did or not of your person.
So it would be fair to say you don't know where certain items were found at the time that you learned of there being items found, correct?
No.
No, as in?
No, I knew those items were found on you in the search. Maybe not the specific pocket, but I knew the officers found those items in your possession.
Were you at the scene of the search?
No.
So how do you know where they were found?
Because they were turned over to Detective Stern as your property.
How do you know where they were found, though, if you weren't at the scene?
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Can we strike that last answer from the record? I didn't refer to any house, grass.
You asked an open-ended question. His answer will stand. Your request is denied.
So it would be fair to say that in the question I did not mention a house, grass, or city? That'd be fair to say?
You didn't mention it, but I know you were found at a house in the city of Waukesha. And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
Can you strike that last answer?
Request is denied.
On what grounds, Your Honor?
You asked the question, he answered it. If you want to limit, ask leading questions and direct him.
That is your right.
You made reference to the house where the detainee was found, the grass, the city. Could it be possible that that's where they were found? The items that you are referring to?
No.
Even though it would be fair to say that you were not present.
Correct.
You made a lot of reference to the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
No, sir.
So it'd be fair to say that you cannot know how a person's body is feeling. That'd be fair to say?
I can't explain exactly what another's body's feeling, correct.
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
I think that depends on the circumstance. In this specific circumstance, you told me...
The last follow-up if he wants it.
Okay.
Next questions.
You made a reference on one of the exhibits. I'm not sure exactly which one it was. It was the first interrogation in the police holding room in the hospital. In that exhibit, you made reference to the FBI being present because you were short-staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence, yes.
And you made a reference to short staff. Can you explain what does short staff mean?
I don't recall if I said that or not.
I don't know if it's exhibit 172 I'm referring to. Can you pull up exhibit 172, please?
We refer to the photo of the identifiers and the items found.
Is that 172?
172, yes.
Well, I don't think, is it 81 then I'm referring to?
81 is the audio recording.
Okay, it's
I'm
81
sorry, 81 is the video and audio.
of the,
Was it just the audio? I was right the first time. It's
okay, I think it's 81.
You would like the audio recording from the hospital.
Yes, Your Honor.
Is there a part you'd like to direct the state to when they pull it up?
Because it's the audio, I'm assuming it'll be probably as soon as the defendant is brought into the room.
It was played starting at 4 minutes and 25 seconds through 14 minutes and 25 seconds. Do you want it started right at 4:25?
Yes, Your Honor.
Okay. The state would please assist with that.
How long would you like it to be played?
Do you know how long you want it played, or do you want the whole thing? The
I don't-
same clip?
I don't need the whole thing played. From what I recall, the point that I would refer to is pretty early in that.
Well, how about we start at 4:25, and then when you say pause, please, when you want it to be paused by the state.
Okay.
All right, go ahead.
I'll tell you. It's Darrell?
Yes, sir.
Hey, Darrell. I'm Jeremy Wojcicki. I'm the FBI. FBI? Yeah.
I'm Mary, yep.
We're just kind of helping out because we're so short-staffed tonight. So, thank you.
It's paused at 4 minutes and 56 seconds. Go ahead.
From hearing the audio on this exhibit 81, do you recall saying that the FBI was present because you were short-staffed?
That is my voice. I don't recall saying it in the moment, but that's my voice.
That is your voice.
That is me talking.
So from your recollection, do you recall being short-staffed at that time?
Yes.
And can you explain what the short staff mean as far as at that time, what would short staff mean?
We're just very short on resources with what happened down at the parade route and the mass casualties and the amount of officers it took to secure that location. We were very short on people.
And
People were called in off duty.
You made reference to the short staff being the reason why the FBI was present.
Yes.
Is FBI usually present in the situation of short staffing?
No.
May we put that off, or do you
Yes,
need it?
I'm sorry.
No, it's okay, I just want to make sure if you needed it, it's up. All right, let's take it
Sometimes I
down.
forget it's too.
Thanks, two of us.
Yeah. And you made reference to recording the interrogation on your phone, correct?
Yes.
And why would you use your phone to record an interrogation? Especially one of this magnitude.
Because the camera in the room didn't have audio capability.
And were you informed of that? Or let me back up. When were you informed that the camera that was in the room did not have audio?
I don't recall exactly. Prior to the interrogation.
And who were you told by?
Hospital security.
Was that the first time you had ever used that police holding room in that hospital?
No.
So it would be fair to assume that you were aware that that room had cameras.
Yes, I knew it had cameras.
And have you ever conducted an interrogation in that room before that evening?
Interrogation, no, but I'd use the room for other purposes.
So what prompted an interrogation in that room that specific evening?
Well, as I explained in my earlier testimony, the situation down in the downtown area of Waukesha where the mass casualty incident had occurred was very fluid. It was still unfolding at that time. We were learning more and more and more about what occurred. We decided to start the interview at that location to see if you'd be willing to shed light on for us as to what you did or did not know. And again, I'll go back to statements I made earlier. There's a risk inherent with every transport. I didn't know where your ultimate final location was going to be that night, so to now start bouncing you from facility to facility to facility unnecessarily was just something we made the decision not to do.
And at some point, the detainee was moved to the Muskego Police Department, correct?
Yes, you were moved to the Muskego Police Department later in the evening.
And when did you learn that that would be a location that the detainee would be going to?
We made the decision to try to use that location after the first interrogation attempt.
Oh, I'm sorry that I didn't hear the last part.
I'm sorry, after the first interrogation attempt.
First interrogation attempt. How would you define attempt?
Well, when we were at Waukesha Memorial Hospital that night, in the police holding room that we've discussed, I read you your Miranda rights verbatim from the Waukesha Police Department Miranda statement form. And at that time, you indicated you didn't wish to speak with me.
So it would be fair to say that the Fifth Amendment right was exercised at that point.
Right to silence.
Under the Fifth Amendment.
Yeah.
So, acknowledging now the fact that the Fifth Amendment right was invoked not to speak, where, as you say, the right to silence, why did you continue to record on your phone?
So we are trained at our police department, when you do an interrogation, the recording is to be left on pretty much until you try to effect transport. So typically what we would do is, if our building hadn't been under construction, and when we'd been able to get you back to our police department, where in that situation we may very well have transported you, just because we would have had a municipal lockup there and we could have held you for the night. But that again was difficult based on the fact that we didn't have that possibility at the time. So if someone's in an interview room and at our police department, we'll leave that, even after the interrogation's over, we'll leave that video running until we come back and remove the individual from that room.
Even once a detainee has invoked their right to silence, you still continue to record? Is that a standard practice of your agency?
Yes, it is, for as long as they remain in the room.
And so when did you start recording?
Are you talking at Waukesha Memorial Hospital?
Correct.
Prior to you entering the room.
So you started recording before the detainee entered the room, and you said you keep the recording on until they leave the room. So would it be fair to say that there should only be recording while the detainee is in the room?
No.
And you did say for the record that that's standard procedure in your agency.
In regards to the interview rooms at our normal police department, which wasn't available at that time, yes.
Would it be fair to say that you were not at the normal police department?
Yes, however, with the audio, I was still trying to make sure I followed the policy to the best of my ability.
Can you show proof of that policy?
I don't have it.
So it'd be fair to say that there's no way to determine if that truly is policy if it can't be proven.
Objection argument.
Grounds.
Sustained. As to the form of the question, it's argumentative.
How can that policy be proven?
Objection.
Grounds.
Sustained on relevance grounds.
Do you know where that procedure is located in your agency rules?
Objection,
Grounds.
relevance.
Sustained.
Grounds for the sustained, Your Honor?
Relevance grounds. Relevance. Not relevant. Next question.
It's not relevant?
No, keep going. We can take it up later outside the presence of the jury at our afternoon break, but for now, keep going.
I follow, Your Honor. I apologize.
Keep going, you're good.
So once the detainee was taken to the Muskego Police Department, that would be a pretty standard police department. Would that be fair to say?
Yes.
And a second interrogation also took place at that police department, correct?
Yes.
Any reason why the first interrogation couldn't take place at the same police department that the second one took place at?
Well, the first interrogation, again, wasn't at a police department. You know, Muskego was utilized as they had a lockup facility, so we interviewed you there.
Around what time was the detainee taken to the Muskego Police Department?
Well, I don't recall the exact time.
And you also stated that another law enforcement officer...
I apologize for the interruption, but I just want to make sure my jury is in good shape. If you want to just take a moment to stand. It's a little slow, I think, for them, so we're just going to stand for a minute. Again, my apologies for the interruption. Anyone on my jury need a break? Are we good? I'd like to keep going. Anyone? Okay. No response to that. They said they're good. All right, we'll sit back down. And again, my apologies, Mr. Brooks. Hopefully you know where you were.
Yeah. It was another law enforcement officer who actually did the transport of the detainee at that time, correct?
Yes.
And you stated earlier in testimony that you and your partner followed behind that transport. Is that fair to say?
Yes.
And I'm assuming at some point that you will actually strike that. You stated to being present during the booking process into the Muskego Police Department. Is that fair to say?
Yes.
So why couldn't interrogation be conducted at that time, which would have been more ideal considering that you said there was a lockup. I forgot how you referred to it, but basically like a room with it, the detainee could be secured.
Well, we had been talking about at that point when we arrived at the facility with you that you hadn't eaten all day, you hadn't slept, so we wanted to give you an opportunity to eat, sleep, clear your mind, and refresh yourself.
And what bearing would that have on interrogation?
Well, I mean, you said you hadn't eaten, you hadn't slept. So I think a person is more focused when they're fed and they're rested, so, we wanted to give you the opportunity to do that.
In your opinion, how would that have affected interrogation?
I'm going to excuse the jury right now, so if our jury, we could stand for the jury so I can take up a legal issue, please. All rise. All right, thank you. Be seated. So I'm going to take up two issues right now. One is when I paused earlier and told Mr. Brooks I would allow him to, it was regarding the policies. I want to know, as the proponent of the evidence, why you think that's relevant. And then secondly, the questions I believe that you are asking related to the interrogation, unless you can convince me otherwise, go to a legal issue that this court has already determined, but I'll hear you out on that. I didn't want to make an assumption, but I also didn't want to have you question this witness about what really are legal issues that this court previously addressed regarding the admissibility of the interviews.
Well, to the first one, about the policies, that's relevant because I think it should be stated for the record why he left his phone recording after he acknowledged that the Fifth Amendment right to silence had been invoked. At that point, interrogation is supposed to stop completely.
Well, I understand what you're saying from a legal perspective, but that doesn't mean the recording had to stop in and of itself at that point. He did provide an explanation on the record.
His explanation was that it's policy, right?
He answered the question, why do you believe having the specific policy and him testify about the specific policy is relevant to his testimony?
Well, I believe that if that's in fact policy, it should be proven. It should be proven that that's a fact, that is a real policy. For all we know, he could just be saying that it's a policy. And at that point, it makes him continuing to record after the Fifth Amendment had been invoked.
Well, right now, you assume facts that are not in evidence, sir. And so you're the proponent of this testimony through your cross-examination. And so without something more, sir, I don't see where there's relevance as to what the specific policy is.
Can you see what I'm getting at, though, Your Honor? If he's saying that this is a policy of his agency, he should be able to prove that that's policy. Because at that point, if there's no way to know that that is the correct procedure that they use every time, then why?
I'm making a lot of generalizations that I don't think are accurate as to what he said. This is a trial, sir, where the allegations in this case are that you drove through the Christmas parade, right, and caused death and injury to a number of individuals. There's also those other charges related to the bail jumping, the battery, and frankly, his conduct isn't on trial. We're not here about a police misconduct trial. I'm not saying that some of this information might not be relevant to his credibility, things of that nature, but you have to, again, you're the proponent of this. Why do you believe those policies relate to an issue of fact in this case or otherwise go to your defense?
I believe that is relevant because it can show that at the very minimum that first interrogation and anything related to it should not be admissible as evidence.
That's a legal determination that I've already raised. Your attorneys represented you at that time. They made a variety of arguments. So to then make this trial about that interrogation, it's not relevant.
I'm not making the whole trial of it.
But the issues are legal issues that this jury will not be asked to answer. I've already ruled on the admissibility. That's a legal determination. So I'm not seeing the relevance to those specific policies, and there is simply no requirement that the state or this witness has to prove those policies. You are representing yourself. Hold on, let me finish. You're representing yourself. I'm not aware of any subpoena that required him to bring those policies with. So that would have been on you if you felt it important to cross-examine him on those policies to require that. I'm not aware of that. Have you done that?
Obviously, it was going to come up.
Did you issue a subpoena ducis tecum to this witness to bring with any of his policies related to interrogation?
How can I do that myself, Your Honor? How can I do that from a jail cell?
You were given all of those blank subpoena copies, sir, and you could have filled that out in a way for this witness to require. You didn't do that. So
who would have served him?
The state would have. They served your other subpoenas. But be that as it may, that's not what we have here. So I believe that your line of questioning is on a topic that's not relevant to the issues in this case. So I'll give you one more opportunity. Why do you believe that questioning him about the policies are relevant to your case?
It's relevant to the case because why would he be recording before people are even in the room and then after?
Well, that's argumentative, sir, so that's not a legal basis.
Once the Fifth Amendment is invoked, interrogation is supposed to stop, period. There's supposed to be no more recording, no more questions asked. That should be the end of the whole interrogation.
These are legal issues that you're trying to raise before the jury. I've already dealt with the admissibility, so you've not provided a legal basis to further question this officer about policies related to the interrogation and the recording. He has answered questions. I gave you some leeway on that, and his answers are before the jury. Certainly you'll be able to argue the meaning of that or the lack thereof during your closing arguments if we get to that point. Let's move on, though, to this issue about why I excused the jury. And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent. You want to question him. What's the legal basis you believe I should allow you to continue with that?
What legal basis are you referring to?
I believe you were attempting to elicit information or evidence, testimony from this witness on issues that are not relevant.
Is that referring to the same question?
Not the policies, what I just stopped the testimony for, because I don't want to create issues in front of this jury related to legal issues that are not before them to determine.
And is that referring to the question about the policies?
No. You were asking him, why did you stop? Why did you not question him further? Meaning, why did this detective not question you when you got to the Muskego Police Department? Why did they wait till the next day? I stopped because I know the law on this area, and I know that when a subject invokes their Fifth Amendment, or when you're a defendant in state, it's the 14th Amendment, but nonetheless, right, and you have rights under the Wisconsin Constitution as well, but that because you only invoked your right to remain silent, they waited to question you until a sufficient amount of time had passed, in addition to the other reasons. I'm not going to let you question him in front of the jury about that specific thing. Or at least I'm cautioning you that I'm stopping it because I don't see where that's relevant, but if you keep pressing him on that, you're going to open up the door to him saying, because I was following the constitutional requirements and giving you a break in the questioning so that I could, right, get a statement I believe would be admissible later on. That's what I'm trying to avoid.
With all respect, Your Honor, I don't think he would have said that.
My concern was we were headed down that path. So if there's some other
So
reason you want to
the 14th
question
Amendment
him,
would have been referring to the having the attorney present?
I'm sorry, say that again?
So you said, when you stated that you know the law in that area about the Fifth Amendment and the 14th Amendment, what were you referring to on the 14th Amendment?
I'm not going to explain that any further, sir. Let me just ask the state if they see this any other way, you think I'm mistaken, and I was concerned we were headed down that path, which would be a legal determination, but if there's something the state sees.
I didn't want to object for that reason, because I just wasn't sure what Mr. Brooks was talking about at that time.
Well, that's fair enough, because if that's what you were trying to question him on, then I think that's fair game.
I agree with Attorney Daisy, that's what I was getting at. I didn't mean to cut you off, but I agree with Attorney Daisy, that's exactly what I was getting at.
All right, well, you understand it's my job to protect the record too, so I want to make sure that, all right, so with that understanding that you are questioning this witness about why they didn't take you to Muskego for the first interview, is that where you're wanting to go with all of this?
That was the question.
All right, well, I might have misunderstood, but in any event, it gave us an opportunity to talk about the other thing, so that's okay.
So is that a fair question to ask then? Because I'm confused now if I'm even allowed to ask that question.
I think part of the issue sometimes, sir, is there's either, sometimes the questions aren't as artfully worded as they could be. I know you're doing your best. I like to look at it this way. Questions that are a sentence at a time, meaning a thought at a time, because then they're not compound, are the easiest for a witness to answer. And when you start bringing in other things, it can be confusing, and then I might not understand, or a party or a witness might not understand what you're asking. So, looks like it's one of those situations where I was a bit unclear. It's been clarified. If that's the line of questioning that you are going to go, then that's fine. Then I would allow that. I'm not going to stand in the way of that. If the state objects, obviously that's a different story, and then I'll have to rule on it, but I think we're all on the same page now.
And just for the record, Your Honor, I will be objecting. I don't want there to be, just because I think this has been asked and answered. He was taken to Waukesha Memorial Hospital for medical clearance. They want to minimize the number of times that he's transported, and they needed the information sooner rather than later. So I will be objecting as to asked and answered. I just didn't want to, he asked the question that the court suggests, and then I object, and so I do want to put that on the record just so the court's prepared for it.
Understood.
The question of why wasn't the first interview conducted at Muskego Police Department had not been answered.
I'm going to let you ask that question. So even if they object, we'll put everyone on notice. So because I think it's reworded a bit differently, so I think it's fair. I'm going to let you ask that. All right? Let's bring the jury back out. It's time. I might have to get me more water too. Thank you so much. You have enough water, sir? You have water?
Yeah.
You have enough?
Run through this one.
All right, we'll make sure there's another one. I can't see the hand monitor. What you got or don't have.
Thank you.
right, thank you. Everyone, please be seated, and Mr. Brooks, you may continue with your questioning of this witness.
And do you recall why the first interview was not conducted at Muskego Police Department?
Yeah, so in regards to the first interview at that point, as I kind of stated in my earlier testimony, we didn't know exactly where you'd end up. Muskego didn't become an option and something we thought of as a final place for you until after the first interrogation was attempted and was over with.
And do you recall if you made that determination yourself, or was it your supervisor or something of that nature?
Objection relevance.
Grounds.
As to where they were going to take you?
Yes.
Overruled. The witness may answer.
I discussed it with Detective Casey.
And at that time, that's when you learned that Muskego Police Station was a viable location?
Yes, that's the point at which we made the decision.
Had you ever used that police station before in any of your investigations before that evening?
Objection relevance.
Grounds.
Overruled. The witness may answer.
I had not, but when our department first closed, that was given as an option for us, being we didn't have our own municipal lockup.
And do you recall around what time you started to conduct the second interrogation?
Yes, 12:11 p.m. on the 22nd.
And do you recall how that interrogation started?
Yes, I explained to you, I had more information about the domestic, and that's what I was looking to speak to you about.
Do you recall making a statement that we all know how women can be, they're crazy?
I do.
And what did you mean by that?
It was just additional rapport building that I've talked about in my earlier testimony. Speaking to you on a person-to-person level, quite honestly, it wasn't a judgment I generalized towards all women in the world. It was just wanted you to feel comfortable talking to me as a person. I felt we had rapport. I felt I could tell that like before you were comfortable speaking to me. And it was just a continuation of that.
So it'd be fair to say that that comment doesn't reflect your opinion of women.
Correct.
Why did you feel that would have been necessary to build a rapport that you stated that you already felt that you had?
Because it was just being relaxed. I was relaxed. I didn't want to make you feel unnecessarily nervous. We had been, talking to each other in the casual conversation from the night before, very civilly, very openly about non-custodial topics. And I was just continuing to go along those lines. It wasn't anything other than to just communicate with you on a stiff level, relaxed level.
And do you feel, would it be fair to say that other comments could have been used to keep the detainee at ease?
Objection, vague.
Grounds.
Sustained as to the form of the question.
Was there any other conversational tools you could have used to keep the detainee at ease?
Objection, same.
Grounds.
Overruled, the witness may answer.
Perhaps, maybe.
So it'd be fair to say for the situation, you felt that the conversational tool you used would be more appropriate at that time?
So ask that one more time, please.
You felt that, would it be fair to say that you felt that at that time, the conversational tool that you used would be more appropriate for the situation?
I don't know that I was really thinking about appropriateness. Like I said, I was just conversing you on a normal person-to-person level was my intention at the time.
So it would be fair to say that you assumed that would put the detainee more at ease by starting the conversation with along those lines?
I wanted you to be relaxed. That's not anything that I did just specifically for you, Mr. Brooks. I always want people to be as relaxed as they can be. I want them to feel comfortable to talk to me if they are willing. It doesn't change the fact that ultimately I have to read Miranda. But I always want all the people I talk to feel comfortable and be willing and know that they can talk to me if they want to.
Speaking of Miranda, do you recall reading the Miranda rights in the second interrogation?
Yes, I do.
Do you recall how long into the interrogation before you read the Miranda rights?
Objection.
Grounds.
Objection, misstatement,
Grounds.
and mischaracterization of the evidence.
Grounds.
Well, sustained as to the form of the question.
It would be fair to say that the second interrogation was pretty long. Would that be fair to say?
Yes, sir.
Do you recall when in the second interrogation you read the Miranda rights?
Your Honor, I am going to object again to the form of the question.
Grounds.
The interrogation began, the court made a finding as to when the interrogation began prior.
I'm going to sustain the objection as to the form of the question. It calls for a legal conclusion. Next question.
Did you immediately start the second interrogation with the reading of Miranda rights?
No, that is not the first thing I stated to you. First, I explained to you what I was wishing to talk to you about.
And do you recall how long you were in that explanation phase of the interrogation?
Maybe around 15 minutes, 16 minutes.
So it'd be fair to say that you didn't read the Miranda rights till somewhere after already interrogating the detainee for 15 minutes at least.
Objection.
Grounds.
Misstatement.
Sustained. Calls for a legal conclusion. Misstates the testimony as well.
You read
Next question.
You read the Miranda rights after 15 minutes.
Yes, thereabouts.
Do you recall why you didn't start the second interrogation with the Miranda rights?
I'm not required to read them immediately, so those first 15 minutes were verifying your personal information, explaining that I now wish to talk to you about a domestic involving your girlfriend, and then I read them before asking you any specific questions about that event.
Would it be fair to say that you had already obtained personal information the night before?
I had, but I didn't have it in front of me, and I have to recomplete the whole Miranda sheet, so I had to refill out the top form of the sheet, which is your name, so I had to verify that.
So it'd be fair to say that you had obtained personal information that you didn't bring with you for the second interrogation?
I did not have your information written down at that point. Yes.
Do you recall why at that time? You didn't have the personal information that you had already obtained?
No?
No, as in,
I don't recall why I didn't have it.
and you said you started off the second interview with information about domestic allegations. That'd be fair to say?
Yes, after reading Miranda, if that's what you're asking.
No, I
You're
didn't.
right, I don't know, what are you asking then? Just so I'm clear.
The question was, again, you started off the second interrogation with domestic allegations.
Yes, that was part of the beginning, explaining to you those allegations that had come forward. Things I didn't know about the night before.
Any reason why you wouldn't explain the real reason why the detainee was being detained?
At that point, the domestic was part of the real reason why you were being held in custody.
Did you have any more knowledge about the incident from the previous night at that time?
Are you referencing the parade aspect of it?
Yes.
At that point, yes, I did.
And why wasn't that information given to the detainee at that time?
As I explained in my earlier testimony, the idea behind the second interrogation was I began with the domestic abuse issues, questioned you about those, and then moved into the parade aspect of the investigation.
And why not start with all the information you knew?
Objection, relevance.
Grounds.
Overruled. The witness may answer.
Can you repeat the question, sir?
Why would you not start the second interrogation with the information that you knew?
In regards to the parade?
In regards to all the information that you had at the time?
Well, as I stated again in my earlier testimony, as we began the second interrogation, I explained it was about a domestic with your girlfriend, Erica Patterson. But again, I can't give you all the details because part of gauging truthfulness and avoiding I'm not leading you is not telling you every single thing. I told you she alleged there were physical injuries, but I can't really tell you what they were because I want to see if you're going to be honest and tell me what they were. Additionally, telling you what the injuries were as far as Mr. Patterson could cause you to create a lie to avoid those, and it's the same issue with the parade.
Did you speak to the complainant of the domestic allegations at that time?
Objection. Do you use the word complainant?
Sustained is to the form of the question.
Had you spoken with Ms. Patterson about the alleged domestic allegations?
I did not.
So it would be fair to say that you, at that time, didn't know if they were true or not?
No, that wouldn't be fair to say.
And why would that not be fair to say?
Well, hold on. It's for this jury to determine the facts of this case, including the domestic allegations. So I'm not going to let a witness comment on his belief or not on any other witness's testimony or information. Fair enough?
I apologize.
All right, next question.
Had you at any time before the second interrogation spoke with Ms. Patterson?
No.
made reference, I believe it was in both interrogations, to reading, it was in reference to the Miranda rights, stating that if I was at home on my couch, do you recall making that statement?
Yes.
And what do you mean by that, at home on my couch? What do you mean by that?
Well, Miranda is strictly custody-based, so I could interrogate you or question you about a matter in which you were a suspect at your home, and I would not be required to read those warnings. Being we were in custody, we're at the Muskego Police Department, you've been handcuffed, you've been transported, custody was obvious. I'm required by law, therefore, to read you those rights based on you being in custody.
You made a reference to that's a requirement by law. In custody, you have to read those by law.
Objection. Relevance for this hearing.
I'm going to sustain that objection. I believe it's also been answered. So, next question.
Do you recall if those Miranda readings are to be at the beginning of the interrogation?
This has been asked and answered as well.
Sustained, it has. It also calls for a legal conclusion, which is not appropriate. Next question.
In the first interrogation, you spoke of the detainee being detained for loitering and prowling. Did you make reference to that in the second interrogation?
No, I did not.
Any reason why?
By the time of the second interrogation, the primary focus had shifted to the domestic incident between yourself and Erica Patterson, and also the parade, because by this point I had more information about the parade and that incident specifically.
So what happened to the initial loitering and prowling allegations? Why were they discarded?
At that point, they were not the primary concern. Eventually, the interrogation came to a stalemate, so to speak, and we didn't discuss it. The primary concern was the domestic issue between you and Ms. Patterson, which at the time I began to start the first interrogation, I didn't know anything about. And then the fact I now have more knowledge on the parade.
So, do you recall who made the decision for the loitering and prowling allegations to be discarded?
Your Honor, I think that mischaracterization of the testimony, the fact that it wasn't charged isn't on this officer.
I didn't say anything about it being
That's
charged.
not an evidence of the other reasons indicated by the state. I'll sustain the objection.
Just for the record, I didn't say anything about it being charged.
Understood. My ruling stands, even with that.
So would it be fair to say that in both interrogations you gave different reasons why the detainee was being detained?
The explanations that I explained to you did change, however, again, the domestic was not known at the time, so that circumstance changed a bit. That became something that was of importance to us. Domestic abuse is taken seriously. And again, there was more knowledge about the parade.
Would it be fair to say that because of the change in information between the first interrogation and the second interrogation that can be misleading?
Objection calls for speculation from whose perspective?
Ground.
Sustained as to the form of the question.
is it fair to say that someone who is being detained would perceive that as being misleading when there's two different reasons why they're being detained that was told to them?
Objection, speculation, this witness cannot know what is in someone else's mind.
Calls for speculation.
At any point in the interrogations, did you knowingly lie about the information that you had?
There was information I withheld from you, yes.
So it'd be fair to say that you lied.
Objection mischaracterizes this officer's answer.
It's argumentative, sustained as to the form of the question.
Just for the record, there is a point in there where you
Sustained
Stated
the
that he
form of
lied.
the question.
why did you continue to withhold information repeatedly?
I guess at which point? Through the whole, are we talking about in the middle of the second interrogation at this point? What
Do both
what are we talking
interrogations.
about?
Do both of them.
Well, there really wasn't a first one, because when I got, interrogation doesn't truly begin until I'm asking you incriminating questions potentially after you've agreed to waive your rights and speak, something you didn't do on the first day. On the second one, quite honestly, it goes back to what I've stated in my earlier testimony. I wanted to make sure the information I was getting from you was truthful. I wanted to make sure that I didn't lead you down a path of potential lies. And third, quite frankly, Mr. Brooks, I didn't believe if I gave you the information you were going to tell me anything.
You made reference to the first interrogation saying that there was no waiver of that interrogation?
Objection.
I'm referring to what he just said at the beginning of the answer.
I'm going to sustain the objection. Next question.
Grounds for the sustain?
Next question.
Grounds for the sustain, Your Honor?
Next question.
So I can't get no grounds. Okay. So you made reference to not being sure if you would, I'm trying to remember exactly what you said. You wasn't sure if you were going to get the information you were seeking?
Correct.
And is that what led you to lie about the information you knew?
Objection mischaracterizes the testimony.
Grounds.
It's argumentative, sustained.
Did that lead you to not be forthright about the information you knew?
Objection. Argumentative.
Sustained as to the form of the question. His words were that he withheld. You may,
That led you to withhold information that you had obtained?
I'm sorry, did what part with all that? Can you restart the question?
Because you were not sure if you were going to get the information you were seeking, that led you to withhold information that you had obtained.
Well, again, as I've stated in prior testimony, strong part of the reason I withheld information is I wanted to gauge how honest and truthful you would be. I think it's important to note, you lied to me, and this was proven by evidence, about your mother owning a vehicle. You know, you lied about coming out here in a tan, possible Kia. So there were lies that were told at this point. You lied about being body slammed by officers. That was later proven to be untrue.
Advise the jury of a couple different things at this point. Obviously, ultimately, the juror will determine the credibility of all witnesses and the weight of the testimony to give for any witness. So whatever any person's opinion about the testimony or previous statements or information from another individual, I'm telling you, is not evidence. You need to determine for yourselves what the facts are in this case. And the other thing I want to remind the jury of is that an accused has the right to remain silent, and when that silence cannot be used against him, since there was a comment earlier. To the extent that it was commented on, I'm going to instruct the jury to disregard that as well. Go ahead.
I'm sorry, continuing. So it just was that.
It's narrative at this point. He's going to ask his next question.
Okay.
If the state needs to redirect, they will.
You made reference to, well, let me back up from that. Is it standard practice in your agency to withhold information in an interrogation?
Yes, it can be to gauge truthfulness.
And what do you mean by it can be?
So obviously, so a person understands what's going on, you'll give them the basics of why you want to question them, but you're never going to tell them every detail because you want to see if they're being truthful. You want to see what details come out.
So would it be fair to say by saying that it can be means that it's not all the time used in that fashion?
Oftentimes it is. Oftentimes there's information that I won't tell a suspect unless, it's something where I've actually caught the suspect in the act and we both saw the same things. But yes, typically if I want to make sure they're telling truth, if there's certain information I have, I will withhold that. I'll see if they're willing to provide that, and if not, at some point confront them with that information.
You had a partner with you during both investigations, but I'm referring to the second one primarily. Would that officer had used the same method if they were taking the lead in the investigation at that point?
Objections, calls for speculation.
Sustained is the form of the question.
Would it be fair to say that the way you interrogate is your method specifically?
Yes.
So it would be fair to say that that is not standard policy of your agency?
Correct.
You made reference to the suspect's family. Specifically, I'm referring to the children. How were you able to come into the knowledge of the suspect's children?
I believe I asked you about them.
I'm referring specifically to where they lived at the time of the incident.
That was information that came afterwards. Well, actually, I don't recall. I don't remember if you told me specifically where your older daughter lived that day or not.
will we be fair to say we saw a lot of the second interrogation? Would that be fair to say?
Portions of it.
Well, yeah, portions of it, but a lot of it.
I don't know exactly how much we watched. That's really, I guess it depends on your definition of a lot.
At any time, do you recall it being stated where the defendant's children lived?
Not that I can recollect watching today.
Had you seen that video before today? The
Yes.
second interrogation?
Yes.
Have you seen it in its entirety?
Yes.
Do you recall, well, scratch that. In reference to the second interrogation, in reference to finding the phone, did you ever find the phone at the detainee?
You asking if I personally did?
Yes.
I didn't, no.
Do you recall where the phone was recovered?
In your vehicle.
When you say your vehicle, who are you referring to?
Your mother's red Ford Escape that you were driving that day.
So it'd be fair to say it wasn't my vehicle, as you stated. Grounds.
Sustained as to the form of the question.
And what was obtained from that phone, if you recall?
I don't recall.
Do you recall asking for the code to get into the phone?
Yes, sir, I do.
At any time, did you learn at any time if the phone was able to be opened up?
I don't know if it was or not.
So what would be your reason to ask about the phone code if you didn't intend to open it up?
Objection mischaracterizes the testimony.
Grounds.
Sustained as to the form of the question.
Did you yourself intend to inspect the phone?
No.
So why would you ask for the code?
Well, because for the purpose of the investigation, we have people that are trained in doing that types of thing, getting into the phone, downloading the digital evidence, if they're able. So having the code would assist them in being able to do that when that time came.
And do you recall if it was more than one phone that you were attempting to access?
Yes.
Did you ask for the code for, well, back up. How many phones were you seeking to gain access to?
I believe it was 2.
And do you recall asking for the code for the second phone?
Yes.
Did you inspect the second phone?
Me personally?
Yes.
No.
from your recollection, what would be the significance of the phones at that point in the investigation?
Well, it's really this digital evidence that could be inside. So as it pertains to domestic abuse, it's not known if there's going to be any phone calls between yourself and Ms. Patterson. Some of the data, location data, can be relevant. Although you were arrested in Waukesha, it still helps to show that data as well. So things of that nature. We really don't know what could or could not help us until we try to see what's in there.
At any time during the first night that you were with the detainee and during the second day, which would primarily be the second interrogation, do you recall there being any drugs and alcohol in related to the detainee?
As in whether you were under the influence?
Yes.
No, you were not.
And do you know that to be fact?
There were no signs of impairment that I observed.
Did you smell any alcohol?
No, sir.
Did you smell any drugs?
No, sir.
Did you find any alcohol or drugs?
No, sir.
And during both those days, that the night of the first interrogation and the time spent during the second interrogation, someone was always with you when you had contact with the detainee. Would that be fair to say? Meaning you never had interactions with the detainee just strictly by yourself?
Not that I recall.
So it was always you and someone else?
I believe so.
Well, you were always with your partner though, correct?
Well, I mean, he may have used the bathroom at a point. I don't remember. If I was ever alone, it was very short.
But from the best of your recollection, you were just never, for a period of time, just by yourself with the detainee.
The second day before transport, there was a period of time when Detective Stern stepped out of that interview room at Muskego. And I don't know how long it was just you and I in the room, but that's all I recall.
But nothing extended from your recollection?
No.
And was it your belief at the time that you were set to conduct the second interrogation that you believe that without the FBI present, the detainee would likely be more willing to speak with you?
Objection, speculation.
Grounds.
I'm sorry, can you repeat that again?
Was it your belief that the second interrogation without the FBI's presence, was it your belief that the detainee would be more likely to speak with you at that time?
He may answer, go ahead.
Yes.
And do you recall how you came to that determination?
Yes, it was a sense of how I felt you interacted with me, the night before. As I stated with you, or stated in testimony, we had casual conversations. Part of those casual conversations were talking about sports you played, sports you enjoyed, the Packer game that day. You seemed very calm, very relaxed. How you seem right now, Mr. Brooks. And I sensed the nervousness with the FBI being present. I thought you might be comfortable talking with me, and that's why I decided to just have it me and Detective Stern.
You made reference to how I seem right now would be consistent with how I seemed that first night. How would you be able to tell that just by observation?
Calm, lucid, your speech is clear. You seem to be knowing what you want to ask. I understand there's been some questions that have been clarified, but you know where you are and you know what you're doing right now.
Would it be fair to say that you can't say for sure how I'm feeling at this moment?
Objection. Not the question that was asked, and argumentative.
Sustained as to the form of the question.
Would it be fair to say that at the time of that first interrogation, you weren't sure how I was feeling?
I guess I can't get in your head, but you presented yourself as being very calm and very comfortable.
Based on your observation?
Correct.
Do you yourself have any training in psychology?
No, sir.
And there was a point in the second interrogation when you were attempting to show the detainee a video. Almost as if you was forcing it in his face. What were you attempting to show the detainee?
I was attempting to show you a video of when you drove your vehicle through the parade route.
Any reason why you were being so forceful in trying to do that?
Well, I felt it was very important for you to see the damage that was caused from the incident. And Detective Stern made the statement as well. You were asking for more information, so we attempted to show you more information.
Would it be fair to say that the question of asking for more information was asked even on the first night during the first interrogation?
Yes. Yes.
Do you recall making a report of the night that? Let me back up. Do you recall writing a report of your interactions with the detainee on the first night and the second morning?
Yes.
And did you write the report yourself?
So how it's done is I dictate it and then it is typed by someone else.
What do you mean by dictated?
So there's a phone system that I talk into and it's recorded and then it's later typed.
Do you recall who types it?
One of our clerical staff, I don't know specifically who it was.
So you made reference to a phone. You gestured with your right hand and made a phone, I guess, symbol. So I'm assuming that records what's being said. That'd be fair to say?
Yes, when I'm speaking into the phone.
And at that time, speaking into the phone, were you stating verbatim? Was it off the top of your head what you remember, or did you, I guess what I'm saying is, did you speak into that phone based on a report that you had already previously written or had obtained?
Well, I guess I want to make sure I understand the question. Could you ask it again so I understand?
I guess I can be more clear. I guess what I'm trying to say is, like, by speaking into this phone, would that have been what you recalled at the time, or would it been based on a report that was already written by you or someone else?
Okay, there was no prior report, so that what I speak into that phone and what is typed is my best recollection of the events at that time.
That just gave you a little clarity. I knew what I was trying to say, I just couldn't. So at that time, when you spoke into the phone, you hadn't yet filed your report at that time.
Correct. As I'm talking, I'm completing it. So it goes into a recording and then it's later typed.
And then is it filed after being typed?
Yeah, eventually it's sent to court.
Do you recall if that was, I'm guessing that would be the night of the second interview or sometime after that?
Yes, it was the night of the second, after that interview had been completed.
After that second interrogation, had you learned any more information additionally that you didn't have during the first and second interrogations?
Yes.
And did you put that into your report?
I believe I did, if it's the one thing I'm thinking of, yes.
Do you recall how many reports you filed in relation to this incident?
I think 4, maybe 5.
Why so many?
Well, you have to understand that after the second interrogation, the investigation wasn't simply complete. There were additional things that need to be done, and additional things I assisted with that led to other supplements being done.
And do you recall, well, let me back up a minute. You said 4 or 5 reports?
I believe so. I don't know the exact number.
Do you recall when the last one was completed?
I believe in June.
And would the June report contain additional information that you didn't have in November of 2021?
I don't recall either that or clarification. I'd have to see the report, I guess, to know exactly what you were driving at.
You don't recall what you reported?
Not exactly.
So it'd be fair to say you don't recall what you reported in any report except for the first?
That is the one that is most clear because it was such a substantial piece of what I did in this investigation.
And that was the one when you spoke into the phone and it was recorded and then typed?
Well, they were all done the same way.
All reports are done the same way. And do you recall coming to the Waukesha County Jail to serve any warrants in relation to this incident?
Yes, I do.
Do you remember what they were for?
Yes, it was a search warrant for your jail property.
And do you recall what that jail property was?
Property that would have been turned over to the custody of jail when, at the time that you were, so personal belongings.
And what would personal belongings refer to exactly?
Are you asking, it could be anything you had with you. Are you specifically wanting to know what I seized?
Yes.
Your red t-shirt that you were wearing on the 21st and 22nd of November, the blue jeans, as well as socks.
And do you recall why you needed to seize the clothing?
Yes, the determination was made to go back and seize the clothes as it's the items you were wearing during the event. The parade event is what I mean by event.
Would that be the only reason why you needed to seize the clothing?
There was also possible DNA evidence, but I do not know how that came back.
Did you yourself inspect the clothing?
I just retrieved it from the property, put it in a bag, and brought it back to the police department.
Do you recall if you seized anything else besides the clothing?
Not from your property at the jail, I didn't.
And do you recall if that was the only time you came to the Waukesha County Jail to serve a warrant?
Correct, that's the only time I recall.
Do you recall when that was?
November 30th, 2021.
So roughly about a week after the incident?
9 days.
And you made reference to bringing it back to the department. Did you learn who would be expecting the clothing?
No, I believe it would have gone out to the state crime lab.
Did you obtain any additional information from the state crime lab?
I don't believe I received any information from the state crime lab personally.
I want to go back a little bit, specifically to the night of the arrest. When did you arrive on scene to Elizabeth Street?
Shortly after you had been taken into custody.
When you arrived, what did you see?
Can't recall exactly. I believe you were already in the back seat of a squad car.
So at that time, suspect was already detained.
You were detained.
Suspect already
Suspect
detained.
is you, Darrell Brooks.
Can you strike that last comment?
That was his response. It will stand.
And did you do any search of the area at that time?
I did not know.
And what did you do from that point?
At that point, myself and Detective Stern were assigned to follow Specialist Mark Howard, whose vehicle you were ultimately placed in, and follow him to our substation, where you were taken.
Do you recall? Well, let me back up. Do you recall seeing a lot of different law enforcement there from different jurisdictions?
Yes, I do.
What else do you recall about the scene as far as law enforcement personnel?
Basically just that they were there.
Do you recall any weapons being drawn at that point, or?
I did not see any officers with weapons drawn when I arrived. There were officers with rifles across their chest, but they were not pointing them at anyone.
Any distinct vehicles, to your recollection, utilized by law enforcement?
Just squad cars, marked squad cars that I recall.
Do you recall seeing the vehicle that was more like a ground rover type vehicle?
No, sir, I don't.
And so once you came to the scene, learned that the suspect was in custody, you followed the other officer to I'm guessing the police station or whatever it was?
The substation.
Substation, I'm sorry, substation.
Yes.
And what information did you have at that time in regards to the investigation?
The information, again, was still very limited. That you'd been loitering in the area, would receive calls, and that you were identified as a possible suspect that was in the vehicle.
Did you yourself receive those calls, or any of those calls?
You mean as in like the phone calls?
Yeah, in reference to the loitering.
No, those went into dispatch, and then they were broadcast over the police radio, which I heard.
And did you immediately respond to that radio call?
Yes, I made my way to that area.
The area of Elizabeth Street.
Yes, sir.
Do you recall what time that was?
It was right around, took place over a few minutes, 5:30, 5:35, getting a little after 5:30.
And what time did you arrive to the scene?
I don't know the exact time.
I want to go back to the phone really quick, in reference to the phone. In the exhibit that we were shown, you made reference to not wanting someone else to claim the phone. Do you recall saying that?
Yes.
What reason would someone else claim a phone that isn't theirs?
Could be their own reasons. One thing we have to do once we have possession of property, we have to make sure that we release it to the appropriate person. So that would be important.
Is it fair to say that all property obtained from a detainee is sealed?
I guess, what do you mean by sealed?
Like placed in a sealed bag, pursuant to whoever's the property belongs to, it's sealed.
Typically, we would take property and probably put it in a paper or plastic bag. We don't necessarily seal it and then place it in a locker.
Would you write on the bag who the property belongs to?
Well, if it's personal property and it's going to be returned, it would go in a locker, typically that's associated with their cell. But if it's evidence, it would go, to a different place. It depends on the type of property you're talking about.
Would it be some type of identifying something to identify the property to the owner of the property?
Yes.
When you came to the Waukesha County Jail to serve the warrant for the clothing or personal property, as you stated it, was that property sealed?
It was in a secure room.
Was it sealed?
Like the bag it was in? No.
The bag was just wide open?
I don't recall if it was wide open. They have it in a property bag that, I don't know the exact conditions of it.
Did it have any identifying name on it, or a birthday, or?
They utilized a system in which they looked up your name and the bag had a number. The number was associated to your name. So they were able to find it that way. And then, once I got in the bag, I recognized the clothing as your clothing.
So it'd be pretty fair to say that the system that they use is pretty easy to identify what property belongs to whom.
It seemed to be. To get the specifics on it, you'd have to ask them, but, they looked up your name, hit a number, and your bag came right across.
Does your agency use a similar method?
No.
What method does your agency use to identify a property?
My agency would simply, well, we're not a large county jail, so we only hold about 5-6 people at a time. We would take personal property, put it in a paper bag, put that paper bag in a locker that typically would correspond with the cell number that you were placed in. And then your property would also be documented on an electronic form, so we knew it belonged to you.
You made reference to not being a large county jail. Are you referring to the holding station?
Our standard department that we're back in now has a municipal lockup. Correct. It's very small.
So it'd be the holding station.
They call it the police station, the booking room.
Police station, substation, holding station.
Yeah, correct.
At any time during the second interrogation, were there any other law enforcement watching the interrogation from another location?
Yes, there were.
Can you explain why?
Well, again, the FBI was present in a different room because we still did not know whether there was a terrorist nexus to this incident at that point.
Is that the only other law enforcement that was watching the interrogation?
There may have been some of our own officers. I don't know how, if they were moving around the building or, I don't know what they were doing.
So it'd be fair to say you can't recall if
Correct.
If at that time there was still uncertainty about the nature of the incident, to the point that the FBI still were kind of involved at that point, any reason why they wouldn't accompany you and your partner for the second interrogation as they did with the first?
Objection, relevance.
Grounds.
Sustained. Relevance, 90611.
Is there any reason why the FBI can induct their own interrogation?
Objection. Calls for
Grounds.
speculation.
Sustained.
If you knew at that time that you and your partner would be conducting the second interrogation, why did the FBI need to be present?
Objection, relevance.
Grounds.
Asked and answered. Next question.
Answer?
It's sustained.
You said asked and answered?
You've asked why the FBI was there multiple times. You're 90611, please move on.
Is it standard procedure for other law enforcement to watch interrogations from another location?
Objection, relevance.
Grounds.
Overruled, you may answer.
I wouldn't say it's standard, but this wasn't also a standard incident.
So the magnitude of the incident is what prompted the change?
That's right.
Do you recall who made that determination?
Objection, calls for speculation, relevance.
He asked, do you know? So overruled, the witness may answer.
So I'm sorry, just so I understand the question correctly. Why the FBI would, is the question why they'd be there at all?
No, that wasn't the question.
What is it again?
The question was pertaining to standard procedures,
Okay.
and I believe the question was,
You asked who made the determination to allow for other agencies to observe the
Right.
interview or interrogation.
thank you, Your Honor.
You're welcome.
I don't know exactly. I only know that the FBI became involved due to the terrorist concern, so that's why they were there.
My question wasn't towards the FBI, it was law enforcement in general. Just to give more clarity, the question was, did you know who made the determination for other law enforcement to watch from another location?
No.
Were you at any time aware that there would be other law enforcement watching the second interrogation?
I knew the FBI was coming back, yes.
Did you know if there would be any other law enforcement outside of the FBI, like from your agency or anything like that? Were you aware that they would be watching as well?
Objection relevance.
Grounds.
Overruled, the witness may answer.
Not that I knew of.
But you do recall other law enforcement outside of the FBI being present?
Yeah, so we had an officer, based on you being in our custody, that had to stay in the room with you, their jail area for the night. I don't know how much of the interview that officer was or was not present for from another location.
Do you recall leaving out of the interrogation room during the second interrogation?
Yes.
And at that time, did you speak with any other law enforcement?
FBI.
And do you recall what those conversations were about?
Not specifically, no.
Do you recall if there was directives given by the FBI?
Objection hearsay.
Grounds.
Yes, do you know, not what they were. You may answer.
I don't recall if they gave directives.
Do you recall your partner stepping out of the interrogation room at any time?
Yes.
Do you know if they spoke with FBI at that time?
If my partner did?
Yes.
I don't know.
At any time during the second interrogation, did the FBI leave?
Not that I know of.
So to your recollection, they were there the whole time?
I believe so, yes.
And I want to go back to the phone for one quick second. You made a reference to the kind of code on the phone. Do you recall what that was? In reference to the phones that you were intending to access.
You talking about, there were two, one of, any one phone specific? You talking about the iPhone?
Yeah, the iPhone. I'm sorry.
Yes, you gave a pattern code.
And what about the other phone?
No code was ever provided that I recall.
And do you recall if those two phones were placed in evidence?
Yes, they would have been.
And did you place them in evidence?
I did not.
Do you recall whom?
I do not.
During your investigation, what? Let me back up. I don't want to say what. No reference to the suspect being involved. During that initial information that you received, did you receive information that there were multiple suspects at any time?
We're talking about the parade incident at this point, yes, no?
The parade incident, yes.
Initially, yes, so, and I've covered this in prior testimony as well, it was very chaotic early on, and there were reports of possible multiple suspects, yes.
That just about does it. No further questions.
How much redirect, if any?
I have some, I would think I could get done in 10 minutes.
All right, I'm just gonna have my jury stand for a minute. I need one too. And anyone else in the courtroom may do that.
All right, thank you. Please have a seat.
Exhibit 174, which has previously been admitted into evidence. Do you recognize this form?
Objection, leave.
Overruled, the witness may answer. It's been testified to previously.
Yes, I do.
Sir, if you talk to the same person 3 different times while they're in custody, do you have to fill out a separate form each time you talk to them?
Objection,
Overruled, the witness may answer.
3 times.
Yes.
Would you have to fill out that top portion of the form each time?
Yes.
That's all I need for that exhibit. When we talk about, do you recall Mr. Brooks' questioning of you with regard to the recording made by your cell phone at Waukesha Memorial Hospital during the first meeting with the defendant?
Objection, I don't consent to being called that name.
Noted, overruled, the witness may answer.
Yes, I recall.
Are you familiar with the term excited utterance?
Yes, I am.
Reading.
Oh, overruled, the witness may answer.
What is that?
It's when an individual, whether it be Mr. Brooks or any individual, begins making statements on their own accord and not response to a question. Typically, an utterance may reference why they're in custody in the situation that you were either questioning them about or preparing to question them about.
Is it important to capture those types of utterances on tape or recording?
Objection speculative.
Overruled, the witness may answer.
Yes, it is.
Would that be a reason to continue recording after an interview's been ended?
Objection, answered that already.
Overruled, the witness may answer. It's redirect.
Yes, it would.
With regard to the two phones, you indicated that someone else located the phones in the defendant's car, is that correct?
Yes.
And in order to access the contents of a phone, if it's passcode protected, do you need the passcode to enter it?
Objection, leading.
Overruled, the witness may answer.
It makes it easiest. The men that do that, the men and women that do that do have ways around it, but it makes it much more difficult without it.
And would it be fair to say that there's not all software can enter into all phones without the passcode?
Objection speculative.
Sustained as to foundation.
Have you had experience in your position as a detective seizing phones off of defendants?
Yes.
And have you had opportunities to turn those phones over to your forensic unit to have them analyzed?
Yes.
When you don't have a passcode or a swipe pattern, have you received those phones back with information that they were unable to be accessed?
Objection, asked the form of that already and answered.
Overruled, the witness may answer.
Yes, I have.
So if you're not provided a code, or you're provided an incorrect code, there's a possibility, or are you definitely getting into that phone?
Objection, speculative.
Overruled.
No, there is certainly a possibility that we would not be able to access the content.
You've talked about on cross-examination your reports that you dictate over a phone line. Do you recall that?
Yes.
Those you testified were based upon your recollection?
Correct.
Do you take notes during interviews?
Objection speculative.
Overruled. You may answer.
Yes, I do.
Do you use those notes at all when dictating your report?
Yes, I do.
The defendant asked you about multiple suspects. You having information about multiple suspects. Do you recall that line of questioning?
Yes, I do.
Did the defendant ever tell you that there was anyone in that car other than him driving it and possibly Erica Patterson?
Objection, leading the witness.
Overruled, the witness may answer.
No, he did not.
And finally, you've been a law enforcement officer in Waukesha County for approximately 18 years, is that correct?
Yes.
Who makes the charging decision when deciding what charges get issued in a criminal case?
Objection, leading.
Overruled, the witness may answer.
The prosecuting attorney at the Waukesha County District Attorney's Office.
You don't decide on the charges?
No.
Objection, relevancy.
It's overruled. You may answer.
We can forward what we believe is appropriate, but we don't ultimately make the decision to charge.
So when Mr. Brooks asked you, what are I being charged with, did you have any ability to tell him that?
Objection, I don't consent to being called that name.
Noted, overruled. You may answer the question.
No, ma'am, not with 100% certainty, no.
Nothing further, thank you.
All right, thank you. Detective, you may step down. Ladies and gentlemen of the jury, as Detective Carpenter is stepping off, I will read the instruction that I've read to you every day, but it's important that you hear it again. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite you telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. And while I still have you here, I neglected to tell you one thing about an exhibit that was received. Exhibit 81 has been received by the court. With that, you are excused. Thank you, everyone. 82. Boy, it's been a long day, but okay. 82. Thank you.
All right.
Yep, you're right. 82. Had 81 in the brain. All right, thank you, everyone. We are in recess. We'll see everyone at 8:30 tomorrow morning.